Welcome to the Veri DAO channel. I'm Lisa Davis, and today we're going to have a discussion about a missed opportunity for the SEC on giving some guidance for tokens in the secondary market. We'll be right back with Nick and Reggie and Trey right after this. Welcome, gentlemen. Thank you for joining me today. I think there's been a lot of exciting things happening and some surprises in the courts and big news in the library. We'll talk about a little bit of that later. We had some of our partners in the Veri DAO do some evaluations on, go back through and look at the judgment, or no, I'm sorry, settlement, and really looked at trying to get some clarity on the actions of the SEC, and would love to get Nick. You work with ICAN and have a history with both in and out on both sides of the fence with the SEC, and so we'd love to get your feedback on just really if the Veri token ever was adjudicated in that settlement. We went through and saw that, I think they said it was mentioned over 150 times. There was a direct reference to the Veri token specifically, that it was related to using different identifiers, Veri token, offering token cryptographic token, Veri R securities, digital assets, and then offering digital asset securities, unregistered securities, sale of such securities. They went on. And so we're just really wondering kind of what your feedback is on that. And then they went on, and the complaint left no ambiguity, only certain clarity as to whether the agency considers the Veri token a security. Then they went on in the settlement and used words, every other word except token. They used digital assets, frozen assets. They even used, when they were talking about Ethereum, Bitcoin, any security not so registered, all of these things. So can you tell us or give us any kind of clues why the connection between the token and the security designation was omitted in the final settlement?
I'd like to jump in before Nick answers and give a disclaimer, if that's correct.
Sure.
So I'm here to participate in the discussion in the library. I am in no way discussing, opining, commenting on, or supporting any position on the Veritaseum litigation or litigation, including Reggie Middleton or any of the Veritaseum assets. So I am totally ring-fenced out of this discussion. And I want to make that very clear in case anybody wants to decide that I somehow have part of this conversation. So act like my square is blacked out until you finish discussing Veritaseum and NCP.
Yeah, we're going to have a couple of conversations in this. We're really excited to have Nick here. He's very knowledgeable and wanted to get his point of view on a couple of things just to help us educate the public and unpack some of this and the consequences of the actions that the SEC has taken and where that has put people down the road in real life situations. Go ahead.
Sorry, I was just going to say maybe I'll keep my observations a little generic too, for Reggie's benefit, but also because I haven't delved into the specific allegations the SEC made in that case. But they're all the same. The allegations the SEC makes in one of these cases compared to one of the other ones, different in terms of the specifics, but they're the same in terms of the generalities. So normally the approach the SEC takes in these cases is they say there was an offering of a token, and that offering should have been registered as an offering of securities. If you go and you look in the laws, the statutes, there's a definition of what is a security, and there's a long list of things that are in there. Things we're all familiar with are securities like stocks are securities, and there's a list in the statutory definition of a security, and stock is in there. What you won't find in the list of items that are securities is token, because obviously it didn't exist when the 1933 Act or the 1934 Act was passed. So, and this would be familiar to your viewers already, what the SEC says is that the offering of these tokens presents an investment contract. An investment contract is one of the things listed in the statutes in the definition of a security. So, and that's where you get into Howey. Howey was the case that talked about, well, what is an investment contract? I mean, people enter into different kinds of contracts all the time. Not all of them are investment contracts. So that's why we end up with a Howey analysis in these token offerings, because token is not listed among the things that are considered securities. So you have to go to something that is listed, investment contract. Then you have to figure out, well, what is an investment contract? And is this offering of the token an investment contract? So that's where you get the connection between security, which is defined, and the Howey test. I think a problem arises because the way the SEC litigates cases, when they settle a case, there's an order or a judgment entered, and generally those orders and judgments prohibit the defendant in the case from violating the federal securities laws in the future. What it doesn't do, it doesn't provide any clarity for those of us who might want to interact with a token in the secondary market. The judgment, the settlement doesn't say anything about whether those secondary transactions involve securities, because the case that started it all talked about the offering at the beginning of the launch of the token as being an investment contract. It says nothing about whether the token itself is a security. So maybe I'll pause there, but that's sort of where the disconnect comes. And I think if you're talking in terms of a missed opportunity, the SEC is not interested in clarifying whether secondary transactions are themselves involve transactions of securities. They don't have an interest in clarifying that in an underlying enforcement matter.
So they possibly specifically left that out because they know that there is a law that actually protects secondary holders or tokens, not tokens necessarily, but they protect secondary markets. So maybe that's why they didn't bring it up specifically.
I think they would put it a little bit differently, and I'm not in the business of giving them the benefit of the doubt. But
sure.
Our case. They would say our case addressed the initial offering of these tokens. We, the SEC, haven't weighed in and see no reason to weigh in on secondary transactions. That's not part of our case. We might bring a case later on having to do with secondary transactions, but we, the SEC, we're just going to address in this case whether the initial offering was an investment contract and therefore a security. We don't need to get to whether or not secondary transactions are securities transactions. That's a different case, they would say. And maybe we'll bring one of those cases later. And I know we're going to talk about the library case in a little bit. And this issue did come up in response to the amicus brief we filed in the library case.
Before we get to that, there was another issue that in the notice, they said that the Veri tokens mentioned in Schedule A were called digital assets, just as Ethereum and Bitcoin. Both Ethereum and Bitcoin have been declared non-securities by the SEC. And so why are they using this term digital asset? And I found an article that I thought was interesting where our friend, Mr. Gensler, makes a statement. This is from Bitcoin Magazine, and when talking about digital assets, Gensler comments how, in his opinion, such developments already exist and don't demand decentralization to function. The chairman also drew a parallel between the US dollar and the concept of digital currency, downplaying their differences. Quote, the US dollar, the euro, the yen, and most public companies are digital, he asserted. You buy and sell stocks that are digital. You buy and sell treasuries that are digital. There is no physical treasury debt any longer. I tend to call these digital assets. So if he's making these kind of statements, would you say that he believes that everything's under the SEC's purview at this point? That even the US dollar, the euro, the yen, all stocks, all treasuries, I mean, are digital assets, everything is a digital asset, because they're using the word interchangeably all through this document.
So I'm never going to purport to be able to tell you what's going through the mind of Chair Gensler. I think it's the way you phrase the question. Obviously, you're making a point, Lisa, and that is that not all digital assets can possibly be securities. And I don't think Chair Gensler would go that far. I think he would say there are a lot of digital assets. Some of them are securities, some of them are not. And to come back to the point that I think we're going to talk about here, you can, in an offering of a digital security that is a security where the underlying digital asset itself might not be. This is sort of the difference between the oranges in Howie's orange groves versus the offering of an investment contract involving those oranges. So,
hey, Nick, for our audience's justification on that point, could you go a little bit deeper about the Howie test? And I know we're going to get to that because you addressed it in your amicus on the library case about the original Howie case, what it was, and the similarities between oranges and tokens today. Could you go a little bit deeper there?
Sure. And again, I can't take credit for coming up with this observation, but I think it's a good one. In the Howie case, there was a promoter, Howie, in Florida, who had some orange groves, and he enabled people to invest in the orange grove operation. And the question in that case was whether the investment opportunity was a security, whether, going back to what I said before, whether it was an investment contract. So again, if you go back to the Securities Act of 1933, there is a section that says securities means, and then there's a list. And on that list are stocks, some other instruments, and investment contracts. So in the Howie case, there was no sale of stock in this orange grove operation. Rather, there was a contract. You could invest money, and Howie would and his company would operate these orange groves, and you would be entitled to some of the profit from that operation. So nobody was saying that the oranges were securities or that the orange groves were securities. Rather, they were saying, the SEC was saying, or the federal securities laws and the court was saying that the investment opportunity, the investment contract, was an offering of a security because you were entering into this agreement whereby you were entitled to profits from the managerial efforts of others. In other words, Howie was going to manage the orange groves. So if we try to take that sort of analogy to the token context, you could say that, and the SEC has said, the investment contracts whereby people could put money in and they would get tokens, in the view of the SEC, creates an investment contract, just like Howie did with the orange groves. That doesn't mean that the tokens themselves are securities any more than the oranges were securities. And that's the distinction we tried to make in the amicus brief, was even if the SEC's right, which the court in the library case agreed with the SEC, that those initial offerings were investment contracts, that says nothing about whether the tokens themselves are securities. And and I'm sorry I keep jumping back to the library case, but that's the point we're trying to have the judge recognize in library cases. Judge, even though you've ruled against the library issuers on the question of the initial contracts being securities, investment contracts, don't go so far as to say, you don't need to go so far as to say the tokens themselves are securities for purposes of if you and I want to interact with those tokens. And so we're trying to encourage the judge, and the judge has already raised this issue at a prior hearing, so we think he's receptive. So that's the Howie oranges versus investment contracts, tokens versus investment contracts. Just because you have an offering doesn't mean the underlying instrument is a security itself.
Right.
Well,
And even even let me ask this. Let me go a little bit deeper. Even on the initial distribution offering, for example, with Veritaseum, or you can even say the XRP case. I know you've done some very good work on the XRP case as well. Because you own XRP doesn't mean that you have investor rights, distribution rights, percentage ownership rights in Ripple Labs. And Veritaseum is much the same way. The Veritaseum token was issued as prepaid access to a software platform, much like a Microsoft subscription is prepaid access to the Microsoft platform. So you keep going back to the SEC is basically saying the initial offering is where we are bringing our enforcement into play. We believe it is a security because it is a offer of an asset that requires the issuing entity to perform in order for there to be value proposition. Right.
The provision in the 1933 Securities Act that the SEC uses is Section 5. The non-lawyers won't talk about that, but Section 5 says any offering of securities must either be registered or exempt from registration. So Section 5 focuses on the offering, which is a very important piece. So it's the offering that needs to be registered. They're not saying the instrument itself needs to be registered. So the offering in the typical token distribution happens at the outset of the thing. There's a white paper. In a different context, you might have a private placement memorandum or some other document that governs the offering. You're going to give us money. You're going to get something in return. It's that offering that needs to be registered.
Gotcha.
And that's the SEC attacks. So if the SEC prevails and some court agrees, or by settlement, there's a judgment that there's an acknowledgement that offering was a security because it's an investment contract, that doesn't tell you anything about what happens next.
Right.
So now you've created these things that are out there, tokens. It just doesn't say anything about the status of those tokens. If you were doing it in another context, and I think the point you're making, Trey, and what you got out of the offering was a stock, and you had some voting rights, and you had some, ability to manage the company as a shareholder, then the thing itself might be a security.
Right.
Because it's a stock. It's listed again in the statutory definition. But here we're in new territory, so it's not clear, and the SEC hasn't made it clear about what happens next. Okay, the offering, let's concede for purposes of argument, the offering should have been registered as a security because it was an investment contract. We just don't know what happens next to people who received a token in that offering.
Right.
So
Understood.
Does that automatically just protect the tokens because the tokens have been moved to the secondary market without being without having the SEC's purview on them in that first offering or whatever?
Right.
So now they're the leftover, they're the byproduct. They're in a secondary market now. So they wouldn't be labeled a security because they wouldn't be under the purview of the SEC anymore at this point.
So I want to be careful here. The SEC will have one view of the world and the rest of us might have a different view of the world. So I think the answer is it's not defined. So we don't know is the answer. The SEC would not say that just because you had an offering and you created something that was different than a stock, that doesn't mean you're automatically protected. I think what the SEC would say is, well, it depends. It depends on what it is that the people who purchased the token have and what are the qualities of that token. And maybe it's a security, maybe it's not. So I think the answer is we don't know. That
goes into kind of my last question around this issue, and then we can go into the library amicus more. Is there a possibility of being protected by a double jeopardy? Kind of leaning off that last question is if the SEC were to go after token holders in the secondary market for Veritaseum or XRP token holders, could it be a double jeopardy situation?
Probably not. So double jeopardy normally refers to you've been convicted once of something or exonerated on something, and so you can't be prosecuted for it again. Here, the SEC would say, well, the secondary market holders of these tokens, they're not the same party that was pursued in the initial action. So that doesn't really, a double jeopardy concept wouldn't really apply there.
But because you're in the secondary, you're only created because of the first, like you're convicted in the first, you survived. You only exist because of the first, you know? Yeah. So they want to have their cake and eat it too. And so many situations.
Yeah, I see what you're getting at. We can be pretty confident the SEC will say, no, we get another bite at the apple. We get to make a new argument against new parties. I think that's probably unfair, but I think that's the way the SEC would see it.
And I guess Lisa, the biggest part of this is that the laws are made in Congress, and these laws just haven't been made yet. And I know we're not going to beat the dead horse of the SEC enforcing. But anyway,
I think that there's, one of the big things that we at the Veri DAO have a big beef with whatever agency is out there is the ambiguity that we're all faced with in this new reality, this digital reality that we find ourselves in. Lisa, do you have the clip of Gary Gensler expounding upon his opinion of the XRP token? Could you play that?
I do.
Nick, I wanted you to watch this because I've got a question going forward. And I know that this was probably done under Jay Clayton and not Gary, but let's go ahead and listen to the clip.
Ethereum is quite big. A currency called Ripple that you might hear in the banking sector, currency called Ripple, currency called Ripple that you might hear in the banking sector. Central banks already issued digital currencies. It's called bank reserves.
Can you dig it, sucker?
Now, the key to making money in a situation like this is to position yourself now before the settlement. Because by the time you read about it in the Wall Street Journal, it's already too late.
So I thought that'd bring a little levity to the conversation. It's obvious that Gary hasn't made up his own mind about what an XRP token is. Is it a currency? Is it a digital currency? Is it a security? Obviously, the SEC has changed their mind between when Gary made that statement and when they prosecuted Ripple Labs for the current ongoing litigation that's underway. So what's your opinion? Is something like that able to be used as a defense against enforcement by the SEC of the offering?
Yeah, well, as I'm sure you're aware, the SEC, the Ripple defendants have tried to make much of statements made by Bill Hinman, who was a senior SEC staffer at the time. I haven't seen anyone try to make anything out of that clip where he's referring to, well, first of all, he refers to the Ripple currency. But anyway, I think, you already anticipated, Trey, what the SEC might say. This was a statement made out of context by Gary Gensler as a private citizen. The commission that brought the case didn't even involve, Gensler didn't vote on the initial complaint that got filed. He wasn't there yet. So, but it's certainly very interesting. And I think it highlights the lack of clarity. And are they better classified as currencies, which would take them out of the securities bucket?
It's interesting as you say that. If I'm not a lawyer, but I watched a couple of legal shows when I was a kid. So if the opposition were to say this was made by Gensler as a private citizen, I would retort, was this private citizen qualified to opine upon digital currencies? Now, any answer you give wouldn't be a good answer. Think about it. No, he's not qualified to opine. Why is he doing it now as chairman of the SEC? Yes, he was qualified to opine. Hence, his opinion, even as a private citizen, should go as evidence against the current action?
I mean, I like the argument. The rules of evidence probably would keep this out. Gary Gensler doesn't get to decide what the commission does by himself. The commission votes on, for example, in this case, in the Ripple case, the staff, of course, the staff being all the people at the SEC who are not the 5 commissioners, the staff investigates. The staff presents the 5 commissioners with a proposal. In this case, the proposal would have been file a lawsuit in federal court alleging that there was an unregistered securities offering, and then the 5 commissioners vote on it. So it's not like one commissioner's view on a particular subject rules how the commission does things. But I mean, again, it's interesting that he said this. I think it shows that a very smart person referred to the XRP token as a currency. That's at least interesting, even if it's not from an evidentiary point of view, admissible in that case.
Well, that small person actually runs the SEC. I think that's the more interesting portion of it. But
it's an important it's a smart person and a significant person for sure. Yeah.
So this gives us an opportunity, I guess, to transition over to the library case, if that's okay with you, Nick.
Sure.
I know you've spent a lot of time entering legal opinions into SEC cases versus Ripple versus library. I think that there are a lot of similarities between the library token and the Veritaseum token, which is why I kind of wanted to dig into this a little bit deeper. Because the library token, in my opinion, is obviously a utility token. It was created to give access to the library platform, which is a streaming platform, and it gives the First Amendment rights to everybody that wants to have a voice. And so I think that it was a brilliantly crafted project, just like the Veritaseum project was brilliantly crafted. Unfortunately, it seems like the innovators at the tip of the spear often get the most friction. So if you could you give us a little bit of background on your amicus in the library case?
Sure. So, first of all, the organization that I'm the president of and on whose behalf we submitted the amicus brief is ICAN. It's the Investor Choice Advocates Network. I raised that not as an opportunity to publicize us, but because we think it's important in some of these cases to bring the perspective of the investor, who so often gets lost. You've got a legal battle between typically the sponsors or promoters of a token and the regulator that sometimes kind of leaves out who the SEC purports to be speaking on behalf of, which is
we felt that pain. Yes.
Yeah, so that's why we think it's valuable to submit these briefs to bring a perspective that may not get appreciated by the judge in this fight between the issuers and the regulators. In the case of the library matter, as you probably all know, the judge entered a summary judgment order against the library folks, and that summary judgment order says, hey, we have litigated this and we know what the facts are and we don't need a trial. Either judge can enter an order declaring the SEC the victor on the issue of whether the initial offering was a securities offering that was not registered or exempt from registration. So the judge did that. So the liability phase of the case comes to a close at that point. Mm-hmm. And what happens next is the judge would enter an order about remedies or what's going to happen going forward. Mm-hmm. And so the typical, as I'm sure your viewers know, the typical SEC judgment following liability says a couple of different things. It says the defendants will not violate the law going forward, and the defendants will pay some money. Those are typically the two aspects of an SEC judgment. At the hearing on the remedies phase, where the judge was talking to the parties, the judge and the counsel for the library folks raised this question that we then put in our brief is, well, what about people who currently hold these tokens? Does your honor's order that you're going to enter impact what they're able to do? Can they use the token, or can they buy and sell the token to other people? Is your order going to impact any of that? So the judge, we thought, asked some very thoughtful questions and created an opening for us to file the amicus brief. So our amicus brief says basically two things. We asked the judge, when you enter your order, please clarify that you are not intending to restrict in any way any secondary market transactions, buying and selling these tokens, and any so-called consumptive use. So if it's a utility token, using the token for the purpose it was designed to be used for. So we were asking the judge to do that, to clarify the final order that it would not do those things. And the legal basis for our argument, we had two arguments, some of which we've already touched on here today. First, we said the difference between the orange and the investment contract. Mm-hmm. So the token, all that the SEC has shown, and the judge agreed with in the library case, was that the offering was an investment contract. That's the only thing that was proven. There was no attempt by the SEC to say the actual library tokens were themselves securities. So let's limit your order. You don't need to say that, Judge. You don't need to say that the library tokens themselves are securities. You don't need to go that far. So don't, and make it clear that you're not saying that. That's a different case, which the SEC would be the first to concede. So we don't know whether or not the tokens themselves are securities, even if the judge found the initial offering to be an investment contract. Point one. Point two, even if the judge were to conclude that the tokens were securities, which we say he doesn't need to do and shouldn't do, there are lots of ways for people to buy and sell securities on the secondary market without requiring any sort of registration or restriction. So even if you were inclined to find that the tokens themselves are securities, there's lots of reasons why you shouldn't restrict people's ability to buy and sell these tokens. So those were sort of the two legal arguments that we made. It's interesting, the SEC has now had an opportunity to respond. Mostly they ignored us, which is fine. Yeah. But there were a couple of sentences.
That's a commonality.
Right. Basically, the response from the SEC to the amicus briefs was, Your Honor, that's all kind of hypothetical and it's off in the future. And they're so, in a sense, they're sort of implicitly agreeing with us. Like, Judge, you don't need to go that far. You don't need to address these topics that ICAN and the other amicus parties have presented. We're not asking you to do that, which would be fine by us. Like if the judge just said, I'm limiting my order to the defendants and the initial offering, that would be fine. And so we're somewhat optimistic the judge will clarify the limitations on his order when it comes out.
What's the timing on that, Nick? When is the judge going to come out with his final judgment?
It's a good question. There is oral argument scheduled. It might even be as early as this week. I haven't gone back to look at the schedule, but if the judge is inclined to hear oral argument from the parties, that hearing would occur, and then it's really up to the judge to decide how long it could take. And there's no sort of set timetable. The judge could issue a ruling in a week or 6 months or longer.
Now, I know that John Deaton has also filed an amicus into this case and has been accepted. And I read some of his tweets recently where he may be invited into the court to be a respondent in favor of the I don't even know who he represented. Did he represent the token holders?
Naomi Brockwell was, I believe, who he's representing. Okay.
Are you prepared to go in and present oral arguments to the court, or is that something that you anticipate happening?
I actually talked to John this morning.
You did? Okay.
And,
good timing.
Yeah. So I don't think the judge will be inclined to give us time, which is fine. I mean, we're not a party to the litigation. That's the definition of an amicus, is we're a friend of the court. Mm-hmm. We are not a party to litigation. So I actually don't anticipate the judge wanting us to take up time at the hearing. We'd be more than happy to give the judge further explanation of what's in our brief. But I think the judge is probably going to be more interested in hearing from the actual parties, the SEC and the defendants.
Yeah, understood. So really your argument comes down to a proper application of the Howey test. And I thought one of the more critical analysis that you brought to light was that, listen, Howey was back in the 40s or 50s?
40s, yeah.
And so 60 years, 70 years later, we find ourselves with digital assets in the news and being brought up for not only codes and laws made by the Congress, but obviously pursuant to the SEC's application of former law. How important is it that you bring to the light that we're dealing with a new time, a new asset that requires us to relook at the word security or investment contracts? Because I noticed one of the main points that you made here in your argument was that, Howey was 70 years ago. We really need some clarification that's up to date.
Well, I think it's very important. One thing I want to be careful of is, careful what you ask for. Clearly, we talked about the statutory definition of a security. So it's a list of instruments, and stock is the obvious one that we can all sort of appreciate. And then there's investment contract, which is vague and ambiguous. And so as a result, we've had to live with the Howey test since the 1940s as each new type of investment.
Mm-hmm.
Sorry,
we lost you. Sorry.
Yeah, sorry. The weather in California, I think, is messing with my connection, or it's the SEC, maybe.
I wanted to say that, but I didn't. So
yeah, low blow. I'm pretty sure it's the weather. So I do think that we are the digital asset space, blockchain technology is really new stuff. It's not just, hey, this is a different variation on orange groves. Because it's so malleable and it is so different in the way it's decentralized. I do think we are at a point where Congress needs to take a fresh look at this, and we just can't keep using this investment contract vague term. It's reached the breaking point. It's
whose place is it? Oh, I'm sorry, Nick. I apologize. I think you just froze, and I thought you were done speaking. I'm sorry. Whose place is it to push that on Congress? Is that we, the people, need to go to our congressmen and women and say, it's time for you to look at these and make a law? Does the crypto community need to go and self-regulate and come up with, a proposal of law ourselves and go to Congress with that? What would you say as like a healthy solution?
Well, sorry, I keep freezing, but I do think it is partly we the people, because if not the citizens, one way that this debate could get resolved is by competing regulatory bodies fighting over who gets jurisdiction. And, that will generate one outcome. Is it going to be the CFTC or the SEC or somebody else who has the primary responsibility? I think in the absence of citizens voicing an opinion, that's probably how it's going to get decided, is the regulators will present something and Congress will sign off on it.
But even then that's two old regulators making laws on a new product with old laws, right?
Yeah,
that doesn't bring new laws to or new ideas to the table.
That's a good point. Yeah, that's right. And I suppose, again, if the regulators get to draw up the new laws, that will benefit the regulators. So right. I think it's an opportunity for ordinary people.
On that note, the regulators have had since 2009, which is 13 and a half years, to provide clarity. And it appears that they opted not to. So without an impetus to act, the act might not occur. It probably will not occur. I know the industry has been asking for clarity for some time. The industry lobbyists and individual participants, even defendants, The clarity has been, to the best of my knowledge, all cryptos are security except for Bitcoin.
Well, and I agree with you, Reggie. There has not been clarity, and we've seen the regulators say, "What are you talking about? We've provided plenty of clarity. Go read Howie, look at your token, and figure it out." That's what passes for clarity. I think what would be the way you phrased it there, Reggie, was everything except Bitcoin. Well, if the SEC has lots of tools, and we might have talked about this on the last time we got together, but the SEC is able to say through no action letters or through public pronouncements, if you design your token in this way, you will not be a security. And they haven't done that. So I think defining what is not a security is how they provide clarity, how they should provide clarity, rather than just in one case after another saying, yeah, this one's a security, this one's a security. That doesn't provide clarity because the technology is so changeable and modifiable. And so what we really need is someone to say, this is not a security. We're pretty sure Bitcoin is not a security, although from the excerpt Lisa played before, maybe Chair Gensler's rethinking that, and the US dollars are maybe securities. But I think that's where we get clarity, and we haven't had it, is by the regulators saying the end of our jurisdiction is here. We don't have that yet.
Trey, has the SEC responded to the amicus briefs? I know they requested leave and extra time to respond. The amicus brief for Ripple, the SEC versus Ripple.
They have not given our attorneys notice that a response is forthcoming. So my assumption is that they've taken the amicus and read it. I know that they've read it because they've made some statements in the response. In general, they didn't mention the Veri DAO. I don't know if they mentioned ICAN in their response, but
I've seen it.
Yeah, but they've definitely, we've got their attention, at least, because the Veri DAO has made several statements, and our struggle is that, and I'm sure that Nick has a lot of clients that Paul Hastings that are in a similar position. All we want to do is do the right thing. All we want to do is pay our taxes. We want to pursue our passions with the law on our side. We want to pursue our passions in cryptocurrency with the blessing of the regulators. And, we've spent a tremendous amount of our own funds and our professional time pursuing no action letters, making statements in amicus briefs, making public statements on Twitter about our passion for the cryptocurrency space and the need for us to cohabit with the regulators in this new economic reality. And so we would love to get some kind of response from the SEC. Unfortunately, in our discussions with the SEC in the form of no action letter requests and what are the other actions, Lisa, that we've taken? FOIA requests.
Yeah, they can't find.
I can't find
the times when
things.
They've contact us. Yeah.
Yeah. Unfortunately, we've either been ignored completely or had the regulator shake their finger at us and say, "You better not do such and such because you're handling an unregistered security." And that was an off-the-record comment that
they won't put it in writing.
Yeah, but they won't put it in writing. So our experience with the SEC as a regulator that's motto is to first and foremost protect the public has been frustrating, to say the least.
Okay, I think it would be helpful. First, another disclaimer. I am not a member of the Veri DAO. I was just invited on as a guest, and because of a consent agreement that I signed, I'm stepping out of the entire SEC Veritaseum conversation. But for those who are just seeing the video, I noticed I don't think anybody introduced Nick and his background. And you should also explain to everybody who the Veri DAO is for anybody who's just looking at this video and hasn't seen it previous.
Yeah, the Veri DAO is a group of Veritaseum enthusiasts who have come together since the SEC took action against Veritaseum in 2019. Our interests are finding partnerships for the Veritaseum IP and promoting our clarity on the use of the Veritaseum token, since the SEC has broken the contract between Veritaseum and the Veritaseum platform, the Veritaseum companies. So we're seeking clarity because, we're left like the library case. There's a bunch of people who hold library tokens who are unsure about what they hold. And so we were just seeking clarity about how we can use them going forward, either in a utility fashion or in swaps or in commercial use going forward. So we're trying to play on an even playing field.
I'm going to put in one more ICAN plug, if it's all right.
Yeah, go ahead.
One of the reasons, and I don't represent Reggie, I don't represent anybody on this call, but one of the reasons Reggie is being so carefully mentioned is consent agreement. The SEC, when it settles cases, and I've represented lots of clients in settled matters, requires that settling defendants neither admit nor deny the SEC's application. ICAN submitted, one of the amicus briefs we submitted was actually in a Supreme Court case. ICAN was on a brief with Elon Musk and a few others. You can go read it on our website. Again, bringing the investor's perspective to those consent orders where the settling defendant is essentially gagged and unable to talk about the case or the settlement really harms investors. And in my view, Reggie should absolutely be. I don't represent you, Reggie, but you should be careful, and I think you're right to be careful about commenting on anything having to do with the case. ICAN takes the view that, hey, we investors, we want to know what settling defendants have to say about the settlement of a case. And so it's just another example of these settlements where the SEC will not allow settling defendants to talk about the settlement. Just really is not helping investors. We should, what are you afraid of? We'd like to hear about it. Right. I want to know what he has to say about the settlement.
Amen to that.
We shouldn't say anything. So anyway, it's just another issue that has nothing to do with how that ICAN is trying to, speak on behalf of investors where that voice is getting lost.
Yeah, I've seen one argument, and I think it might have won, that the SEC gag order is essentially contractually signing away your First Amendment rights. I can't remember where it came from, but
yeah, it did not win. The case that we submitted an amicus brief on behalf of. It involved a case from a long time ago. A senior executive at Xerox settled with the SEC. We didn't represent any of the parties in that. And then later in his life wanted to talk about his settlement with the SEC and was afraid to do so. So it absolutely has First Amendment implications. But sadly, the Supreme Court did not take the case up. And so, that's a fight for another day.
Yeah.
So it didn't lose. It just hasn't been decided or presented yet.
It didn't lose at the Supreme Court. The argument did lose at the appellate court level. The Second Circuit Court of Appeals said that it was not a violation of First Amendment. And then the parties tried to appeal it to the Supreme Court.
To the Supreme Court.
What was the summary reason for them saying it wasn't a First Amendment violation?
The government and the Second Circuit said, look, you voluntarily settled. And settlement.
Sorry.
No, I know. And we made the point that and again, I know nothing about your case, Reggie, so I'm not talking about your case, but it's financially ruinous for people to try to take on the federal government and litigate a case. So you're presented with really a Hobson's choice, like settle or, fight the federal government and be, bankrupted. It's not really much of a choice. So
not commenting on the federal government and SEC, but if I was a comedian on stage and I ridiculed somebody saying, so why did you give him your wallet? You agreed to give him your wallet when he stuck the gun to your head. Yes, I did. I'm guilty as charged,
Fight for another day.
So, it's all these missed opportunities for clarification that, good if they were really looking out for we the people and who they claim they're looking out for, they could take these opportunities. So it'll be interesting to see what happens on the library case. I really wish they would look at our amicus, even from the SEC versus Ripple case, if they'd look at the Veri DAO amicus, they could see the consequences of not, being so ambiguous. And like we started this conversation off with, where, they specifically, 150 times mention the token in the complaint and then specifically leave it out in the settlement. So I think that leaves the people in the lurch. So
the Japanese thanks the U.S. government for that. So.
Hey Nick, this has been a fascinating discussion, and I really appreciate you taking time to talk about the library case and talk about the SEC and the law in general. Hopefully going forward, there will be a more defined set of rules for everybody so that we can pursue our passions on an even playing field. If some of our viewers wanted to get a hold of you, where can they find you?
I appreciate you putting the ICAN website up there a couple of times. We have a info button on the website, and we'd love to hear from anybody. And we're looking for new cases, new allies. Really looking forward to a productive 2023.
Yeah. Well, thank you for everything that you do for the crypto space and for the investor. We really appreciate your efforts because we know that there's a good heart behind it. So thank you.
Okay. And also, I don't think you said that he's ex-SEC enforcement, so he knows what he's talking about from actual experience in history. So.
Yeah.
Good
And
point,
we
Reggie.
apologize for putting you on the spot of defending them, but you have so much knowledge of where they might be coming from. And that is the knowledge base that we're really looking for, because we're just lacking where they're coming from.
My pleasure. It's nice to see you all.
All right, Nick. Thank you.
Thank you.
Thanks.
Thanks, Reggie.
You guys
Okay.
take care.
Have a good day, everybody.
Take care.